May it be please, Your Lordship, I beg to mention item number 16 of today's list.
Yes, what happened, gentlemen?
Lordship, actually, read appellant is not well, so I cannot find my affidavit. He's suffering from jaundice.
You want to file an affidavit?
I could not able to file my
This is a writ appeal. Why do you need an affidavit?
affidavit in reply. I have to file it.
That's what we are saying. In a writ appeal, the pleadings are there in the writ petition. So why do you need a affidavit?
Actually, respondent has already filed their.
All right. Then counsel, your good name, please.
My name is K. Pujari.
Then counsel, Mr. K. Pujari, representing the appellant.
After
Praise,
4 weeks. No.
praise for is granted 4 weeks time for filing affidavit in reply on behalf of the appellant. List up to 4 weeks.
Oblige, Your Lordship.
My lord, if not inconvenient for the honorable court, may I pray for an adjournment in item number 14, Your Lord?
What happened, gentlemen?
My lord, we want
It's a
some more-
fresh matter.
Yes.
14 is connected with 13. That's right. No,
No, Your Lord.
14 is independent. You want time, all right. Then counsel for the appellant. Appellant prays for time. List after 4 weeks.
Most obliged.
Seems that the system has become too prompt. No? You don't want a listing and it is listed. Is it so?
May it please your lordship. Lordship, I would like to mention listing of this PIL lordship 72 of 2016.
16.
Yes, I have filed this PIL. No, there are certain direction time to time.
Okay, so what is the urgency that you want to get it listed right now?
Right now,
Right
lordship,
now means
on Wednesday, lordship.
we are facing the vacations now, eagerly awaiting.
This PIL relates to the traffic, lordship, traffic of Guwahati.
What the High Court will do, madam, in that? Do you have any suggestion that all right, give this direction, remove the traffic from the roads?
No, not
Then-
to remove lordship. There are many directions, and in fact,
That's
in
all right,
December.
madam, these are directions which are not possible to comply, basically.
No, the government has taken, like
We
lordship,
know,
because
though,
of this PIL, they made
But what is the urgency right now?
urgencies, lordship, that was on 18/12/22. In fact, a committee was formed by this court, honorable court. And
All right, get it listed on day after tomorrow.
highly obliged, lordship.
But so I filed a writ appeal, my lord, on 2nd of June, my lord. It has not been listed. Let it come on 21st, my lord.
21st.
Lordship, I beg to mention a fresh writ appeal against an order of the tribunal rejecting my 13-4 notice on the condemnation of delay stage. Lordship, meanwhile, sale notice have been issued. Appeal has been filed on 14 Intel Lordship, Wednesday, Lordship.
Get it.
Daily list for orders, item 1.
May it please, proceed this interlocutory application, my lord, for condemnation of the delay of 35 days, my lord, in preparing the appeal, my lord.
This is that drop teachers matter.
Yes, my lord.
What do you say, Mr. Borpudar? You have admitted other appeals?
Yes, my lord.
The Learned Counsel for the appellants, Learned Counsel for the respondents peruse the matter available on record. The instant interlocutory application has been filed seeking condonation of delay of 35 days occasion in filing of the appeal, connected writ appeal against the judgment dated 31/3/2023 passed by learned single bench in WBC number so and so. Other identical writ appeals have been admitted. Thus, the prayer for condonation of delay is accepted. The delay is condoned, the application is allowed. Registry shall number the connected writ appeal and list the same before the provincialization bench,
Much obliged.
Similar matter is, my lord, writ
along with so and so.
156 of
156.
2023, my lord.
Slip.
My lord.
Much obliged.
Item number 2.
Yes. 7 days.
May I please, Your Lordship? Lordship, I pray for condonation of delay in filing a rate appeal
Hmm.
in connection with rate appeal number 5286 of 2023, Lordship.
What is the order under challenge?
Lordship, this is a writ petition actually earlier filed by the petitioner
Hmm.
against arbitrary act of a company which, from which he took loan and bought a caterpillar, Lordship. So against this, earlier the petitioner had filed a writ petition which has been disposed by the dishonorable court.
Hmm.
And being aggrieved by this order, Lordship, the petitioner has preferred this writ appeal before this honorable court.
What is the controversy, gentlemen? What is the matter on merits? Is the lifting of the vehicle by the hypothetical, the finance company?
Yes,
That is what the,
yes,
or what is the
Lordship.
merit in
Actually,
this matter?
Lordship, actually, in this matter, the petitioner took loan and thereby he took he bought
On
caterpillar
installments, HPN agreement,
installments.
installments
And
not paid, the vehicle
Insta-
seized.
Lordship, the petitioner was paying the installments on regular basis, but the company alleged that he was not, he was a defaulter in payment of the loan money.
So that is a question of disputed question of fact.
Yes, Lordship.
Then
Lordship, if your
all
Lordship
right,
allowed
issue
to,
notice of the interlocutory application, the respondents. Steps for service be taken in 7 days, whereafter process be issued. Rule is made returnable in 4 weeks.
I just,
Item number 3,
May I beg your lordship? Lordship, this I is for condemnation of delay of 80 days, lordship.
No copy of the condonation application is not on.
What is the matter on merits?
Lordship, we have,
Similar affair has been already admitted.
Admitted.
Similar.
So then you will get a copy. All right, this court is informed that this is an application seeking condonation of delay of 80 days, occasion in filing of the connected rate appeal. This court is informed that identical appeal number, rate appeal number
If I'm not wrong,
44 of 2023, lordship.
has already been admitted. Thus, the respondents are duly represented by so and so. Union of India, who is there? Madam is there. All right. Then counsel for the respondents do not object to the delay being condoned. Thus, the prayer for condonation is accepted. The application is allowed. Registration number the connected rate appeal.
only verbally objected.
Have feebly objected. Okay, verbally objected. Condone shall number the connected rate appeal and list the same along with rate appeal number so and so.
item number 4,
May it please, my lord. This application for condonation of delay for 52 days.
Please, what do you say, Mr. Borpazari?
Madam, delay can be condoned, madam. Similar matter is listed today as item number 10.
Okay,
my
delay
lord.
condone connected rate appeal to be numbered
My lord.
and listed for admission. Interlocutory application is allowed.
Obligation.
Oh, all right, then the reasons are germane.
Item number 10 is similar.
But that appeal is not numbered, this one. Let's see what happens in 10. And maybe we can,
item number 5 to 9,
Few of the item number 8, I represent my lord one and my learned friend represent for others.
Mhm.
In that, during the pendency appeal, a settlement order was passed. So we made an application for implement.
Mm.
Some, I don't know how, my lord, I'm extremely sorry that steps, some taken to the advocate's class, steps are not taken. So without calling him, my lord, your lordship will have to hear
the
it.
settlement has been made in favor
Yes.
of third party.
Yes, so my lord, I think your lordship should hear the other side also. But-
Obviously, obviously, if the
will be
settlement has been made, we
will-
can't pass any order
Yes.
without hearing them.
Whatever, but we will be affected. That's why I thought that's better
You
before.
filed an application for implement
Yes, I have already filed.
and senior
Item
counsel,
eight.
Mr. Das submits that during pendency of this appeal, the respondents have passed an order of settlement in favor of, in all cases, it's the same party.
No, it's different. Item 8 is different part.
Only in one case settlement has been.
Settlement order passed.
In the others,
Others, I don't know, my.
Chaudhary,
My lord, there is a stay order. There was an NIT that has been, my lord, suspended by this honorable.
No,
Okay.
Lordship, it was not, stay was vacated, Lordship. We have already settled, Lordship.
in all cases.
In all cases, Lordship.
Vacated?
Your order, last day, Lordship, when Lordship was
Let's see the files, please.
was not there.
Last day, what did you say, Mr. Sharma?
Lordship, last day, Lordship has allowed us to go for a settlement, Lordship, Harveli, Lordship.
Orally.
Orally,
Okay.
Lordship. Actually, this was, this matter is, this settlement was issued without inviting any tender, without adhering any government rules and regulation, Lordship.
In their favor.
In their favor, yeah, against that, Lordship, we have also gone for a cases in the vigilance, Lordship. Cases
Okay.
we raised.
And which is the stay order, Mr. Chaudhary?
My lord.
In which case has the stay order been passed?
The stay order has been passed. That's a common order.
No, it did not continue, Lordship.
2/1/2000.
It did not continue, Lordship.
Let's see.
25/1/2020.
25/1/22 in the writ petition
23.
before single bench.
I 3849.
Dena bhaiya, IA-381.
That is in, my lord, WPC 8169, my lord, the first minute. On, my lord. Second of January, my lord.
It was not continued on 27/2/23.
25th.
There was no prayer to continue.
No, my lord, on 25/1/2023,
The order was passed. Earlier interim order will continue.
Continue, my lord.
But that was not continued on the next date.
No, my lord, that was not, my lord, limited by time.
Well, see, the first order was limited, so it has to be extended every day, sir.
My lord, the your lordship, as we understand.
And then even on 27th February,
Fine.
a mention was made that there was an implement application
Fine.
by Mr. K. Mohammed,
Yes, yes, this is our application.
your application.
Yes, yes.
When, my lord, an interim order is not limited by time, my lord, there is.
You file a contempt then.
No, my lord, I am not filing. They have not, my lord, perhaps not made any other settlement, my lord, except this
So
one.
the statement is coming forth.
Lordship, we have actually that day, Lordship, as per my Lordship, it was paid from their part for continuation. Lordship has rejected it. Harveli, Lordship.
My lord, when there are the materials pending and there is an order, my lord, not limited by time.
We don't know, sir. It's his statement that the settlement has been made. Now you decide what is to be done. We are not making any comments on what has happened.
No, my
If
lord,
you want an implement to be done, you do it. If you want a contempt to file, whatever.
my lord,
that's
with
your
the
choice.
The affidavit, we do not know, my lord, whether this.
All right, Land Counsel, Mr. Sharma, appearing for the AFDC, makes a statement that in all these appeals, the fresh settlement has been made in favor of different persons, public parties. In writ appeal number so and so, Mr. Land Counsel for the appellant, Mr. D. Das, senior advocate, states that in writ appeal number 366/22, an application for impleading the person in whose favor the settlement has been made during pendency of the writ appeal has already been filed. The said application be tagged with the record. Mr. Sharma shall place the relevant orders on record by the next date. List of 3 weeks.
My lord, item number 9, it's a separate matter. I don't know how it has been tagged. It's a different matter.
Mr. Das submits item number 9 that the controversy involved in this writ appeal is different from, has no connection with the dispute which is raised in WPC number so and so, item number 5 to 8. Thus, this writ appeal shall be considered separately. Detached and considered separately.
Yes.
Today,
Yes.
अभी call कर लीजिए 9 number.
9. Yes, 9. 9, my lord.
9 will take up.
Yes.
Item number 9.
Yes.
My lord, there was a tender which was voted by the fishery department.
Yes.
And first tender NIT which was voted,
Mhm.
they again retender it. Retender, and that retender, your lordship will find at page 29. That is at page 29.
Yes.
Notice inviting retender.
Mhm.
So this is the fishery in question,
Yes.
serial number 1, your lordship will find.
Yes, yes.
Walpara. Now, the bid was submitted, and my lord, at page 30, these are the list of documents which is submitted.
Mm.
And my lord, but my technical bid was disqualified. At
On the ground
page
that the Bakijai
35, we have
certificate,
come-
Bakijai certificate
Yes,
was not.
now, my lord, whether no due certificate, we have given a no due certificate. A coordinate bench of this honorable court has already decided. What is the effect of a no due certificate? Bakijai clearance certificate, of course, it is no due to the government. So your lordship will kindly see the judgment of the.
But your
coordinate bench.
list reflects even Bakijai clearance certificate is submitted. Is it correct?
Bakijai clearance certificate is been filed, but my lord, that has to be some period within 90 days effective.
Mm.
On the first tender, we filed that.
Mm.
On the second tender, which was filed, that was time has elapsed.
Time was left.
Time
Okay.
elapsed. That's the ground.
Okay, where is the order?
Yes. My lord will kindly see, we made an RTI, then we came to know that at page 35, my technical bid disqualified.
Just
And at
Yes,
page
yes.
35, that's the order of the learned single judge also, my lord.
just a moment.
Yes, yes.
This only says technical list of technically qualified bidders.
Yes,
Okay, your bid was not qualified.
not qualified.
Then what happened?
Now, my lord, when we are not qualified,
Whether settlement has been made or not,
settlement has been made. To my
the
lord.
notice has to go to the private party.
I think my learned friend.
The
has
representative.
appeared.
Settlement has been made in our favor. We have deposited all the money and we are offered.
You know, that's there, but your lordship has to be 7 years, I think. Your lordship.
It's a
has
7 years period.
7 years period.
Yes. Now what were you
My
pointing
lord,
out?
your lordship, what I submit is lord will issue a notice, my lord, in this case.
All right.
Because settlement has been made in his
Issue
favor.
notice to the respondents and counsel. Since all the respondents are duly represented, process need not be issued. Sufficient copies of the writ
It has
appeal.
been fixed. I'm sorry, my, it has been told that for final hearing, it has been fixed.
It has already been
Yes,
fixed.
yes. 15, 16, 3, 2000.
No, on that, only a request was made, list along with other connected
Yes.
matters.
Yeah,
That's
that's why
all.
this, it has been intact today. So whenever it is convenient after the vacation, my lord.
List for final hearing on, final hearing at admission stage on. You please state a date, whatever date.
After 20th of July, December is coming, 27th.
You make a 27th.
27 is
Yes.
not at 27, Lord, any day.
Please state
Any day.
agreed date, please.
Except 27.
25 also, it's okay, comfortable, 25.
What-
excuse me.
Whatever you say. 25 July, 25th July.
I'm deeply obliged.
Highly obliged.
Listen.
Item 10,
Wait, please, my lords.
Yes.
Lords, connected matter, connected appeal was listed as item 4 today.
That we have condoned the delay as yet.
On the last occasion, my lord has.
We directed a original record to be called.
My lord.
This is that
So it's
water bodies,
Water
water bodies.
bodies.
What does the record see?
My lord,
That's-
the record says, my lord, that the land, my lord, pertains to government. It has been reflected as government land.
No other categorization.
Categorization, my lord, in one column, it is stated that there is no class of land. And my lord, against dark number 602, which my lord, the present petitioner is occupied, my lord, against that it is stated, then, my lord, it is homestead land.
Homestead.
Pratham Basti. Basti means, my lord,
That is what do you say?
habitable.
Habitable land. Yes.
Habitable land. Now, my lord, the fact remains, my lord, that after promulgation of the 2008 Guwahati Water Bodies Act, that is a statute, my lord. My lord, these part and parcels of
The
land.
argument is whether it can be retrospective. By that act, you are trying to convert homestead land into water body. So those who were already there on that homestead land,
my lord, yes.
What title did you have?
My lords, I may-
Did you have any title?
no, my lords.
No.
Then you were encroachers basically.
No, my lords. Under the land policy of 1989 as well as the 2019 land policy, I am actually entitled to occupy or be in that land, and the government is entitled to, it is the duty of the government if I have a right.
What sort of rights are
My lords,
encroachers' rights?
no, my lords,
What right does the encroacher have?
my lords,
Understand.
I'm on the power of the demolition, the said demolition that was done.
Understood, sir. But you are a rank encroacher.
No, my
So
lords.
what right do you have to protect that encroachment?
Homestead land is
Is
permitted
meant to
for,
be encroached upon.
no, my lords,
Then-
that's not my argument.
There must be a process for getting a land allotted.
My lords, I can be categorized as settlers and not as encroachers. And I argue that in this behalf, my lords.
All
So,
right, then we'll admit your appeal. What else?
Only
And-
one submission, my lord, all his submissions will fall down only because of the simple reason that till that he has not made any application before the revenue authorities. I mean, there has to be, my lord, his conduct, my lord.
Establishment of claim at least has to be there.
Absolutely, my
no,
lord.
my lords, there is no, I'm not establishing a claim on the land.
Hmm.
All that I'm saying is that the exercise of power under two different heads was faulty, illegal, and
All
unconstitutional.
right, we'll consider your prayer then. Admit issue notice. Mr. Borpazari has placed, made available for the court's perusal, the revenue record pertaining to so and so. And he shall keep the record available when the matter is taken up for hearing. Admit issue notice.
I'm so obliged, my lord.
Connect with rate appeal within bracket filing number so and so.
Obliged.
My lords, may I be permitted to file an additional affidavit, a short additional?
Counsel for the appellant is at liberty to file additional pleadings if so required by providing advance copy to the respondents.
Much
After
obliged,
providing,
Obliged.
much obliged, my lords.
Item number 11.
On this issue, my lord, similar writ appeal, my lord, already admitted your lordship.
what is the issues?
My lord, here, my lord, petitioner before your lordship are, my lord, drop teachers, my lord.
Drop teachers, admit issue notice, placed before the provincialization bench. Connect with so and so.
Obligement.
Item number 12.
My lord, in this matter, I am appearing for the state of Arunachal. Matter was filed in Arunachal Pradesh, my lord, Itanagar bench, my lord.
Yes,
But we are not receiving that copy, my lord, from the, my lord, Itanagar bench. My lord. So.
you have not received a copy.
Yes.
This is not, I think it has been transferred.
It was
This has been transferred because there was no bench.
Yes, my
It
lord.
could have
Because
heard the
bench
matter.
Matter was transferred, but we are not receiving the record from our office.
Let me take it up the next, by that time he may get it, my,
Oh,
Or a copy may be served to me, my lord.
or we will serve a copy. It will be on
Then counsel-
Wednesday next month.
submits that as the matter has been transferred from the Itanagar bench, he could not receive the record. So in this way, the matter, list after 1 week, so as to enable, list after summer vacation, so as to enable and counsel to.
But the challenge is to transfer order, my lord. The more the time goes in between, my lord.
Otherwise also, Mr. Mazumdar,
My lord,
you very well know the fate of your appeal. Argue today,
after the dismissal of the writ petition, my lord, I had to join to the new place of posting.
argue today. We'll decide it right now. Transfer matters, interference.
Here is a case, my lord, where the transfer was sought to be made in respect of a different person. At the last minute, my lord, the minister inducted me in the statement where the officers who were sought to be transferred.
Ultimately, the order must be reflecting administrative exigencies.
No, my lord,
That part was, my lord, that he conceded. That part also in paragraph 14 of the.
my lord, Honorable Single Judge says
14
that
judgment conceded.
suitability of the persons were considered. And it is not the question of suitability of the person. It's
Mr. Mazumdar, if the order says
my lord.
exigency of service or in administrative exigency, then
My lord,
there's.
record will say something else, man. This is my submission. Lordship can consider the records.
Keep the original record available, Mr.
My lord.
First, my lord, copy may be served to me.
Copy,
We will let the original record
But
be.
that's your burden. You get a copy
Yes,
from your
yes,
counterpart.
yes, fine.
We are giving you time.
No, from
List on 18th July.
my lord, my lord.
in the meantime, land council.
And original records will be necessary, Lord, kindly.
Shall procure his file and shall also keep the original record available.
Copy di din dia, Mal, di.
Item number 13.
May I be the also? My lord, this is my lord, I challenge the my lord order dated 27/4/2023 annexer Roman 3 at page 324, my lord, the last term. By which my lord, I prayed my lord that I may be allowed to, my lord, while the exercise of the my lord, eviction process was there, that was done by the illegality because by dint of a order of the pass of this honorable court, my lord, we were occupying the land and cultivating the land. But fortunately, my lord, after subsequent development was occurred that by notification, that is on 25/1/2023, we are directed to be, my lord, tried to be evicted, and on that matter we approached before the court, and there is an interim order. But in spite of that interim order, they, while evicting us, my lord, they destroyed most of the my lord, cultivation, my lord, whatever we have done, they grow the crops and other things. And subsequently, we filed the petition for my lord, allow us to remaining my lord, crops, whatever there. But that was rejected, my lord. So against that order, my lord, I have come before your lordship. That my lord, already, my lord, more than 70% agriculture, it is already been destroyed. But whatever is remaining is there.
Now, what would be remaining after this spate of rains?
My lord.
You don't think that anything must now have survived after these rains?
It is a less possibility. Even then, my lord, we try to, my lord, collect this, whatever is remaining. And the second thing, my lord, by dint of a, my lord, order of this honorable court, this annexure 12, at page, my lord, the 11% at 80. My lord, we are cultivating. Wherever my lord, the notification under 18A was my lord, declared by under the Wildlife Protection Act, but we are not against that. But there is a protection was that until my lord, we will be settling.
What is the objection in permitting them to collect the harvest?
Actually, once the area has been notified as a wildlife sanctuary, there is a speaking order on record which shows that there are, I mean, animals have moved into the area. In fact, there are Royal Bengal tigers which have made their area there.
In any event, Mr. Council, now otherwise also no one is, even tourists are not being allowed into the wildlife areas. So where's the question of allowing?
But lordship, by have a look at the photographs. This is a large area, my lord. There is not a single tree, my lord, was standing. This is totally, my lord, under the revenue land, and that was cultivating land, my lord. This subsequently by notification. But what's interesting, my lord, point is this: my lord, the complete process of annexation that was done on my lord 14/2/2023, and the notice was issued for eviction that was on 25/1/2023. How that can be done, my lord? Without notifying the land, the complete annexation is completed. That the issuing of the eviction notice, that is also illegal, my lord.
No,
And
whether or not,
prior to that.
sir, after more than 3-4 months having passed, your crops are still standing. Who is going to verify that?
Remaining whatever may be there, my lord, we are not
4
going
months now, sir. 4 months. How can we even think that anything?
Some, my lord, agriculture, it is take some time to, my lord,
So come out with a precise statement. What is standing there?
But we have given the standing statement that the standing crops are there.
What crops? What is the nature of the crop?
This is a Rabi crops. This is my garlic ranges for garlic.
Read your pleadings. Read your pleadings. What had you sowed? What was your crop which you had put in? Let's see. Let's see the genuineness of your claim.
In judgment also it is clear, my lord.
You must have made some representation somewhere. Let's see that.
You have made some representation also, my lord.
Where is it? Let's see.
As per the orders, honorable court order, you have made the representation on first one on, my lord, 13/2/2023, and second one, my lord.
Where is that? Let's see the representation. Please.
Yes, that is his annexure, my lord, at page 99, my lord. Representation.
With 99. 9 is the single bench order.
Yes, my lord. 43, my lord. This is 40/23. This
page
43, my lord.
Please.
Page, my lord. It's just, my lord. This is my lord at page 200, my lord.
Let's see. What are the crops which are growing?
Yes, my lord.
Read from your representation.
During
That will be the
course of
best test to examine the genuineness of your claim. We don't think that anything has been mentioned in this.
My lord, here it is not mentioned, but the petition and as well as my IA that was mentioned, my lord.
Petition, this is the first in point of time. What you have submitted is the representation.
Well, representation, there's something simply saying that.
You don't even know,
allow us to, my lord,
you don't even know what the crops are standing. Then what is to be harvested, sir?
Well, here is written, my lord, the para, my lord, 202, page 202, my lord. Subsequently, on 14 to 2023, eviction drive was carried out and all the members of the petitioner society has been removed by the demolishing their dwelling houses and also large quantity of the standing.
So what, sir, we are asking you the question fourth time. What are the crops which are standing at that time? And anything still remains now.
My lord, is not in given details, my lord.
So then we are not accepting this submission. Get the writ petition decided. Get a direction for compensation if you are entitled. So this is nothing.
But the order, my lord, reflect these things, my lord. Order reflects, my lord.
Order would reflect on your pleadings, but now we see your representation. You don't say.
Name of the crops also mentioned, my lord.
When in your representation, it is not mentioned. So subsequently, whatever you say in writ petition is to be accepted.
My lord, that was not given in detail, my lord, in the representation. Only we prayed for the, my lord, harvesting the cultivation, whatever we, my lord, grown, my lord. And so far, the, my lord, number of the.
Oh, what had you grown, sir? This is now the fifth time we are asking.
My lord,
you.
it is a last paragraph. It is a mention, my lord, 203. It is what mentioning that it's to harvest the all crops and vegetables of the members of the petitioner society. Some of them will be.
No, this is a disputed question of fact. Read 328. Come to page 328. Shri Gogoi has also disputed the claim that there are any standing crops or vegetables.
The
first para.
But at the same time, their affidavit, they are, my lord, saying that whenever we made the allegation that our crops and been, my lord, kept by the other person, they admitted that some incident was took place, my lord. In their affidavit.
Incident took place, sir. For that you will have a remedy in the writ petition. But they have disputed that any crops are standing now.
Initially, although they are saying, but they are also disputing contradictory statement. One day they are saying that there is no crops, another way they are saying that there is admitted in thefts of the vegetables from the said place, my lord. In their
event, now, sir, we can't allow anyone to enter a preserve forest. Now there's a prohibited period.
Then my lord, kindly turn to my lord. This is my lord, this Wildlife Protection Act, my lord. This I want to refer these things, my lord.
Yes.
The section 27, my lord.
Yes.
If my lord this 26A is completed, then my lord the ended that provisions. Although there is a my lord restriction to enter in the my lord forest area under the Wildlife Protection Act, but there is a 27C where it is says that the person who has any right over the movable property. Immovable property within the limits of the sanctuary, my lord.
Oh, so what is the right? What is the right?
Well, this is
were you allottees? Had you been granted any settlement?
No.
You were encroachers.
But the kindly, my lord, see, my lord, the annexer.
Sir, if you ask us to make a comment at this stage, your writ petition might be prejudiced.
My lord, at this lordship had to admit one thing, my lord. That we were not encroacher. Now we are encroaching any land in that area. We, by dint of an honorable court order that is passed in 2016, my lord, they settled there. This was the order of the honorable court, my lord.
Let us see the order. Does the court permit you to settle on that particular land?
Yes, my lord. This is kindly see the annexer at page 77, my lord. It started.
Yes.
Relevant portion at 80. My lord, this third para, this consequence of the allotment of the land to the landless and the victims of the river erosion with the state of
with the state government.
Yes, state government.
Yes.
Required to act as a accordance with ties and lines of lands policy. It is submitted by the.
Examine the case.
My lord.
That is all. The state government was directed to examine the case.
No.
State government did not make the allotment.
Last, my lord, kindly come, my lord. Petitioners are, my lord, there is the last line. The state government my last but three, my lord, the state government shall also examine the representation filed the petitioner and their present occupation may not be disturbed till the petitioners are rehabilitated, my lord. So that was the order. So on by virtue of the dint of this order, we are cultivating and there is no mob at all to evict us. But suddenly, my lord, 2023, the process was mob was attempt was made, my lord. So we are not against that. My lord, only our right, my lord, whatever we, my lord, grown, that may be, my lord, the protection we are giving the undertaking and they can give the protection in that area, my lord, the honorable court single just passed.
All right, Mr. Council will take instructions whether any crops are standing, and if so, whether they can be escorted and permitted to harvest their crops. Find out.
Very well.
Well, Council for the
But my Habis officer, because my lord, the report will come negative, my lord, because the all
If
aspect.
report comes negative, then we don't have any means of getting the evidence.
In the earlier occasion.
Sorry, this is simply a ploy to somehow or the other again get settled on the same line. That's apparent. If you ask us to make a comment, we'll say so. Council for the respondent shall seek instruction whether after proper physical verification, whether any crops are actually standing on the crops of leaf vegetables are actually standing on the land in question. And if so, the possibility of the forest officials, escorting the respective farmers to harvest the same as a one-time measure.
Within 7 days, my lord.
Let's re-notify on 27th.
Item number 15.
Please, Your Lordship, the present matter pertains to provincialization of services. of the
List
school
before the
teacher.
provincialization.
Item number 17.
I know my mind. Where is that? This is my. Where is the details? What in the board? There is an order which has been passed by the honorable court. Kindly see the last order which has been
Just
passed by this honorable court.
the board was directed to carry out an exercise.
Yes, we have carried out an exercise.
Yes.
Some time was also taken last occasion, my lord. Now this exercise has been carried out. Various letters I like to place. Where are the letters? Various letters are there.
Would you not like to place them on record
Yes,
formally?
I will like to place them.
What is the ultimate decision?
Ultimate, my lord, we sat with the urban development and the finance department. And we had a meeting and we said there's a court query is that why not a 6-pay commission should be given to those temporary employees? So we placed that before the finance department. We are waiting from the finance department to get a answer from them.
Let them file them all these communications on record.
After the court's order, what steps we have taken? Your lordship again directed. So what about the other municipal boards?
Yes.
So we have written 102 boards we have written. All these are part of document. We have got 5, my lord, from the 5 boards we came to know. It doesn't give the benefit of those the employee temporary.
What is the stand of the finance department?
Our stand is that, my lord, we have not received any formal communication, my lord, from the administrative department concerned. My lord, that is the urban
development department.
Yes, and once, my lord, we receive it.
Land Council, Senior Council, Mr. Das submits that the exercise in terms of the order dated 21st March 2023 has been started and various communications have been sent to different municipal bodies across the state of Rajasthan and so also to the parent department, that is the urban development department. And the response of the department is still awaited. He shall place all the relevant communications on record with an affidavit.
Yes.
Land Council, who is there for the urban development? Madam, you will be coming?
Return to the finance, PRO department. It should be finance economic department, wrongly sent to the PRU department.
Mr. MS Bora submits that the communications have already been received from the municipality and are being processed for being placed before the finance department.
Yes.
The relevant communications be placed on record. The process to consider the case of the employees in accordance with the observations made in order dated 23/3/23 shall be expedited. Re-notify in 7th August.
Deeply obliged, man.
Item number 18.
Please, your lordship. By the previous order, this one court has directed to file their counter evidence.
He's making some submission. You can please restrain yourself till he completes. Yes.
They have not filed
Your affidavit now, all right, now you answer.
Lordship, this matter may be adjourned as Mr. D. Gogoi is not available today.
He was to file an affidavit. 2 weeks' time was granted. Now it is 4 weeks.
But he's not available today, Lordship.
He's not available today. What has he done in the intervening period? You don't have any idea. It is stated that Standing Counsel Forest Department, Mr. Gogoi, is not available today. And a request is made to adjourn the matter. First off,
My lord.
last opportunity is granted to to the council representing the Forest Department to file the affidavit in terms of the order dated 23/5/2023. List on 20th July.
My lord, may I pray for interim, my lord, not to go for any eviction, my lord, of operation or
Without their affidavit,
status
sir.
maybe status
Without,
today.
without, all right, then we'll give a shorter date. List on 26 June. Yes. Last opportunity, list on 26 June. Deep love leaders.
Item number 19.
May it please, Your Lordship. Also, in fact, I have not been served with the extra copies by the petitioner counsel.
Council for petitioner is still not served copies of the petition to the learned council representing the
That's one number 1 and 2.
response numbers 1 and 2. Need to be done by next date, list up 4 weeks.
Item number 20.
May I please, your lordship. Lordship, on the last occasion, your lordship directed the bank to approach the district administration for handing over the position. Now they approached it, but the district administration is not taking any action, neither they are giving. That is the instruction given me by the standing council. Nor they are taking anything on record.
No, they didn't.
District administration may be directed. to cooperate, my
Yes.
lord.
No, please,
You
no.
represent whom?
Mr. M. Sharma.
For response numbers 1, 2 and 3.
You go
Bank.
ahead. Yes.
Yes, what is your stand, madam?
Lordship, we have approached the administrative, but date is not given.
Yes, madam.
Lordship, last occasion, they said that OC,
They have deposited the money. Why assistance is not being provided?
that I need to take exception, Lordship. I thought that they have.
And you need us to direct the SP to remain present here?
One day, Lordship, one.
One day? All right, MS Bora. It is stated that till date, the possession of the premises in question has not been handed over to the petitioner. Because the submission of the petitioner's counsel is that the district administration is not cooperating. MS Bora prays for short opportunity to complete the instructions, re-notify on 22nd June.
Much of.
Much obliged.
Item number 21.
May it please the lordship. My lord, in this matter, my lord, there has been a new development, my lord. I have received instruction, my lord, that the government is going to issue appointment letters to those candidates, my lord, whose certificates were found genuine in the CID investigation, my lord. So, my lord, may kindly fix this matter after vacation, my lord. Maybe probably on the next day we have to.
Council for the appellant submits that few new developments have taken place. The intervening period NS Kumar, he needs some time to bring these facts on record.
The 1st of August, man.
List on 1st August. Yes, please.
Highly honest.
Item number 22.
Pass. They will come back in hardly 3 minutes.
Basic time now.
Item number 23.
May I please your lordship?
Yes.
This was a interim stage your lordships had to deal. This 3 minor static units at the platforms of
Yes, yes.
Guwahati and Kanaka.
Hmm.
So virtually they have forced us to, they came and closed so that chapter is over, it is closed, we are not operating. Now the matter has come up for admission.
Okay.
There is a short point, my lord. I'll just indicate the point, my lord.
Yes.
The 2010 policy contained a renewal clause. Now, 2017 policy didn't have that renewal clause. So the learned single judge took the view that since it was issued since 2017 doesn't have a renewal clause, the license cannot be renewed.
Right.
Only thing is, my lord, this license, if your lordship's 3 dates will be relevant, the NIT was issued, my lord, on 17/6/2014, page 133. At that time, my lord, the 2010 policy was in force. And the settlement was given, LOA was issued on 17/1/17, which is at page 392. The 2017 policy comes into force on 27/2/17. And there is a clause, which is clause 20. If your lordships kindly see that clause, that is at page, clause 20 is at page 3, applicability 20.2, page 225. If your lordship just have a look at that.
Yes, please.
At page 225.
That's
20.2 at page 22, 225.
225, 20.2.
Yes. Tenders that have been finalized and LOA issued prior to the date of notification of this policy shall be allowed to continue as per policy guidelines prevailing at that time. Zonal railways will cancel all such tenders and return the earnest money in the tenders in cases where LOA has not been issued before the issuance of this. Therefore, our tender was floated when 2010 rules.
Okay, but LOA was also issued to you before this.
Prior to the coming into force of this.
Right. Okay.
Therefore, our short submission is
that you were entitled to continue under the old policy. So how did the learned single bench has dealt with this argument?
I'll just show his view is that since there is no renewal clause in 2017.
No, we understand.
This aspect, the implication of this clause, with respect possibly the learned single judge.
Missed out.
Missed out.
All right. What are these documents you have passed on right now? These are
no, Milord, this is after this, Milord, there is a history. The 2016, Milord, the Supreme Court
18
dealt with these matters.
Yes.
And they said not only, Milord, on the basis of the policy, but on the basis of the directive principles as well, that there is a right of renewal. Because it is a matter.
So these you have placed before us as precedent that in other places the
Yes,
renewal is being done.
and Milord, the railway board has given instructions to them that maintain the status quo of 2019 and continue with all this.
Okay.
So we are saying that virtually the railway board is
Itself considering that.
accepting that, and the matters are pending apparently before Supreme Court also and before that.
Okay.
Therefore, my respectful submission is that there is a matter which your lordships may examine.
So we'll admit the appeal then.
Yes.
Yes,
And,
Mr. Chaudhary.
and Milord, I'll respectfully pray, Milord.
Mr. Chaudhary, what do you say?
It is-
In other
it is
places
not
you have
only for
renewed.
us.
Yes.
Subject to what I'm saying is his lordship. The stay, the relief that has been given by the Supreme Court in the other cases, that pertains to the policy of 2010.
Mhm.
Of course, the matters were taken up much later. It was under consideration of the various courts. It had come up later, but the issue involved in those cases was the policy of 2010.
You understand? What about this clause which has been pointed out? Clause 20.2,
Yes,
where
Lordship.
under the old policy, the LOAs have been issued. They shall continue as per the policy prevailing earlier.
Yes, Lordship.
And,
Once,
and look at these renewals
uh,
at Bombay, other Dadar.
Yes.
I have not seen that.
Even our orders are already there. We have annexed them.
Solid will give you 3 days time, get instructions on this.
Yes.
If different other places you are renewing,
Yes.
then why deprive them then?
Yes, yes, definitely it will not be like.
Senior counsel, Mr. Goswami has drawn the court's attention to various renewal orders issued in favor of vendors akin to the petitioners, appellants. He urges that relying on the Supreme Court's judgment order dated 30th October 2018, passed in WP number 373/2017, the Railway Board itself has taken a decision to renew the licenses of such vendors who had been issued their respective LOAs prior to coming into force of the policy of 2017. Mr. RKD Chaudhary, Deputy SGI, prays for short opportunity to complete his instrument. List on Friday?
Yes.
23rd or 22nd, later, but 22nd. The new vendors have not been put in place. New vendors, sure.
No. Only they have closed the thing. Milord. It
But
was
then
open.
how they are functioning without any vendors?
That is what I'm saying. It is their problem
Chaudhary,
plus the passengers.
Without
problem,
any
Milord.
vendors, how the passengers are being
This
treated?
small-
Lordship, I come back.
It
on
seems to have catch-22 situation.
We have annexed the photograph. It is, they came and put a lock.
that. That was prior, Lordship.
Anyhow, if the other stations, you allowed the vendors to operate under renewals, why deprive them?
Lordship, I.
All over India, they are doing that.
Same discrimination with people of Assam.
Not exactly.
Okay, very well.
We annexed the railway boards at page 280.
Yes.
But this railway board is something.
Okay.
Item number 24.
Yes. Mr. Mishra, how are you doing now?
Covering, my lord.
Recovering.
Recovering.
Okay. Yes.
My lord, today I'll place one interim application.
What is the petition about, sir? Please let us know. What is the petition about?
My lord, I want to bring certain documents, certain official documents. My lord.
We understand. What is the controversy in this petition?
My lord, the controversy is that we have challenged, my lord, the rules which is applicable to the department. And it is known as Nagaland Land Resource Development Department Service Rule 2008. Our grievances is that these rules at the initial stage of entry into the service to the post of assistant inspector has created two wings. One is technical wing and the other is extension wing or non-technical wing.
Okay.
Now, the personals from the technical wing, they can be promoted up to the post of director. But the personnels from the extension wing can go only up to the level of project officer. They cannot go beyond project officer because the next promotional post is the post of deputy director, then joint director and director. So initially we challenged the rule by filing a writ petition, which was, my lord, writ petition number 40 of 2020. And this we filed. During the pendency of that, and my lord, in the meantime, in fact, before us, the technical wing filed a writ petition in 2019, claiming that their seniority list should be published separately, not in a because still there is a combined seniority list. So these two writ petitions were pending. Then certain development took place during the pendency of these two writ petitions. And the initiative was taken by the director, who is respondent number 4 here. He took the initiative and there was out of court settlement.
Okay.
And an agreement was entered into, I'll say it's a tripartite agreement, of course, nothing to do with the labor. It's a tripartite agreement. And according to that agreement, it was agreed that they will provide promotional avenue to the extension personnel also.
Non-technical wing also.
Yes, non-technical wing also. Up to the level of additional director in the agreement, but the director, head of the department will be from the technical wing. On this basis, on the basis of that, and it was also, my lord, that's very important, I must point out to your lordship, clause 3 of the agreement provided that the rules will be amended and will be approved, placed for approval only after the cadre review is done. Pursuant to that, there was a letter from which is on record already, by the commissioner and secretary to the government of Nagaland from that land resource department. He has written to the director saying that, as per your information, the matter is settled to ensure that these writ petitions are withdrawn. Accordingly, instructions were issued that also is on record to additional advocate general. And since this was our writ petitions, we both withdrew it, technical as well. Now, during pendant, after the agreement was executed, within 2 months, they started promoting the personnel from the technical wings. I'll go in detail for once. I'm just
just brief.
Yes. So once they started, we filed a representation saying that please don't promote any because our quota will be finished. We will not get any. All the posts of deputy director would be vacant. So please don't do it, and you comply with the
agreement. Execute the agreement.
Execute the agreement, because on that basis we have withdrawn.
Okay.
Now, but then they continue. And what they did was, I'll not use the word hoodwink, but it is something to that effect. Although the rules were not amended, whilst giving proposal for promotion of respondent number 5, as well as 6, they made a panel list as if we are going to be promoted. Our names were there. This petitioner number 1 and 2, their name were there.
Yes.
Now, thereafter, my lord, when they wanted to promote respondent number 6, we, my lord, filed a writ petition saying that they must comply with the agreement. Until then, they should not make any promotion. The interim order was passed. That writ is 60 of 2022. It is pending in Kohima bench before the single judge. Now, they filed an affidavit in opposition, my lord, in that the respondent number 1, 2, and 3, this government, the commissioner, and the director, disowning the agreement. Disowning that and on the ground was that these agreements are null and void because there is already a rule. A rule is there. You have agreed to amend. And because of that, we have withdrawn our case.
Okay.
So now, my lord, in that connection, there are certain office orders. There are certain orders by the government, which will...
Why this writ petition before division bench?
because, my lord, under the rules.
Now you want to challenge the provisions of the rules.
Yeah, we have challenged.
Rather than getting because they have already withdrawn
Yes.
from the agreement, backtrack from the agreement.
So therefore, we
want
filed
to
this
challenge the
present writ petition.
Okay.
Challenging that. Well, ultimately, your lordship will decide if they don't this thing, but I'm just trying to bring out the
No,
conduct.
we understand. Just
So therefore, I have filed one of the certain documents which we have received later, which is IS 1650 of 223.
You already filed an IA.
It's there, well, before your lordship. 1 year ago.
Yes.
Now,
what do the respondents say about this IA?
no, my lord, we have given,
My lord,
we have given on.
my lord, I think the matter can be decided on merit, my lord. This IA, my lord, these are only records. Eventually, if the rule is not amended, then the rule stands. So they have challenged the virus of the rule.
Yes.
And my lord, the issue is squarely covered by my lord, so many judgments of the Supreme Court, my lord. Based on my lord.
So you don't have any objection in considering these office orders, and there are otherwise also official
My lord,
documents.
our contention in respect of this document would be, my lord, a process is on. Whether that will materialize into an amendment, that is to be seen. So it is yet to see the light of the
Light
day.
of the day. All right.
So like my lord, that the Punjab case where my lord notings in the file, different notings may be there. These are not decision of the government.
Not
decision of the government would be that which is when an administrative order follows.
Okay.
So therefore, my lord, this has nothing to do
Who
with it.
appears for the state of Nagaland?
Yes. I'm appearing for respondent number 2, my lord, the commissioner.
But the state, since the validity of the rules is under challenge, the Advocate General has to appear. That is essential.
I'm appearing on behalf of my lord responding.
Mr. Burgoyne, the observation is that since the validity of the rule is there under consideration, is under challenge, the Advocate General has to appear.
Lordship, no, there is one more aspect what my seniors have stated. The thing is that your lordship will see the repetition basically it has been filed to indirectly coerce the department so that you go back to the agreement. Now it has been well settled because the rule is
Independent thereof, they can't challenge the rules.
basically if you lordship
What is the fundamental prayer, basic prayer in the writ petition?
to declare the rules to be allowed.
All right, so he is arguing only on that.
The thing is that the agreement which they are banking upon, my lord, because it has been based on 309.
Yes.
Article 309. So if there is the promotional revenue which they are seeking, it's a settled decision, my lord. It's a right of promotion, it's not a fundamental. But those issues.
Right to be considered. Yes. So they are saying that they are even stopped from doing that. They can't even be considered because the channel of promotion is not provided in between the same original cadre post. And if you are so anxious, have a look at my judgment in Rajasthan, wherein we read into the rule that the provisions has to be there because there was a case of patwaris, revenue patwaris and land record patwaris.
No, my lord,
The government
based on-
amended the provision.
No, based on educational qualification, classification can be made.
Yeah.
Constitution then judgments
That is
are-
all right. We are not going to those
merit.
matters. But if they are
No, my
at
lord,
par,
only-
if they are at par, then yes.
No, my lord, they are not at par, my lord. They are not having the qualification.
We are not going into merits. But we are saying that as such, the matter can be considered on merits. That's
So
it.
my humble submission is, my lord.
Anyhow, let the Advocate General come, sir.
Of course.
Both
that I
of are
cannot-
you having
that I cannot say no.
spare time for what? Well, since provisions of the rules are under challenge in this writ petition, the Advocate General State of Nagaland is required to represent the state in this writ petition. Then Council MS, what's your good name and what's your good name? Shall intimate the Advocate General to address the court on the next date of listing. And in the IA, the interlocutory application has been filed seeking to bring on record certain communications, office communications, oblique notifications. Since these notifications, oblique communications are part of the official record, they can be considered when the writ petition is taken up for hearing. List on.
My lord, they give a date after the vacation.
My lord, whether I have to file an affidavit and bring it because if your lordship has ordered, if your lordship has allowed this, then should I file these documents along with an affidavit?
They don't object to these being
My lord,
considered.
that of course.
Otherwise also.
Having
They're
regard
all-
to the nature of the document.
Basically, that's what we have referred.
Yeah.
They're all official records.
Yes, yes.
Office orders.
So I can refer from this, my lord.
Yes.
My lord.
Re-notify on.
Can you
Please
give a-
state a date.
My lord.
Fix a date, my lord, because some vacancies are pending.
Let us
If-
know.
If reopening, my lord.
The calendars are there before you, sir.
No, my lord, any date convenient to lord.
My lord,
After reopening, my lord.
if your lordship can, my lord, because I have a matter, my lord, we argued on virtual hearing, my lord. If your lordship can take it up subject to what my learned friend says on 25th, my lord, is the
July?
hearing day. July. And on that date, it can be disposed of, my lord. Your lordship may make it clear.
25th
Could it-
July.
My lord, could it be on my lord? Court reopening soon, guys.
17.
Can it be on 19, my lord?
19. I have-
Or 202?
Will you please, will both of you please decide the date over a cup of coffee and let the court master know.
Shillong, my lord. Let it be on 25th. If my lord.
बहुत cases.
So 26 corridor. 22 तारीख Sunday हो Saturday.
ऐसे कर दो.
22 July is
Saturday.
Saturday. ठीक है.
We have big printed calendars before you. sir. Please have a look.
We have that, my lord. It can be on 27th is a hearing day. On that day, your lordship may dispose it of. I will not ask for time.
Subject to availability of the Advocate General. Madam, you ensure that either he joins through VC or physically.
We will.
Yes, 20. What is the date fixer?
24th, my lord.
24th
is a Monday.
Yes.
24th July. Okay.
Only thing is, my lord, vacancies are there. That's the urgency from the state's perspective.
Today, sir, we'll hear it.
I thought, my lord, the hearing, I came prepared with all the decisions also.
Mr. Mishra is recuperating.
Well, okay.
Yes.
Passed over matter 22.
My lord, the facts of the matter is, this petitioner was recruited to CISF. He, my lord, underwent the training. Before recruitment, my lord, there was a medical examination. There was nothing default found in him, my lord. He underwent the training, completed the training, my lord, then he was appointed on probation. While undergoing that probation, my lord, they have this annual checkup. In that checkup, my lord, it was found that he had a problem with his heart, my lord. There was, my lord, a problem called in the valve, my lord, it's called the murmur, my lord, murmur in the valve. So for that, my lord, he underwent an open heart surgery, my lord, they sponsored that, underwent an open heart surgery. Thereafter, he joined back. His period of probation was being extended, my lord. Thereafter, every year, my lord, he was being subjected to medical examination, 6 months, 7 months. Therein, my lord, they found that yes, he is having this, so he is in shape 2. So, my lord, shape 2 is not admissible for a CISF constable. He cannot be appointed. Now, that medical report says that this was, my lord, contracted in service. My lord, is it strictly attributed to condition of service? No. If directly attributed is not, if not directly attributed to service, was it aggravated thereby? If so, by what specific condition? They say, my lord, the first is that it was contracted in service while he was in service. Second, my lord, attributable to the service, no. Third, my lord, they say that yes, it may be aggravated, and they have recommended that he can be accommodated for non-sedentary jobs. My lord.
Sedentary job.
Sedentary, sorry, my lord, sedentary jobs, my lord.
Yes.
And this continued. This examination continued from time to time. Subsequently, my lord, they terminated his services.
2014.
14, my lord. They terminated his services. And my lord, if my lord can have one of those medical reports, my lord.
We'll admit it, Mr. Nair.
Lordship.
Admission notice.
The only thing, my lord, one factor, the honorable single judge, my lord, gave me everything. But in the last paragraph, my lord, whatever was given was taken away, my lord. That's my only grievance, my lord.
Respondents are duly presented.
Lordship.